My second attorney, Miss Vivian Hodz, Hodz, was aware of how difficult Mr. Davis was being in the case, but she understood my sole objective, which remained getting the financial records and moving on with our lives as quickly as possible, and took on the case anyways. But after this conference with Mr. Davis, everything changed and she was no longer able to help me. And a direct quote from her during that conversation was, "You would need to find the most aggressive male attorney in Tampa if you want to have any chance at getting these records." And she couldn't or wouldn't explain to me what had changed during the conference or since the conference, when the facts and the law hadn't changed. And both Ms. Hodge and my attorneys at Harris, Hunt, and Durr were confident that it was a routine issue, that I'd be entitled to the discovery. So I objected to them withdrawing from my case. There was already a delay in having to change law firms the first time, and I started to see that there were some serious problems in how Mr. Davis was getting away without making any attempt to comply with a stipulated discovery deadline. And that's just not something that goes without consequences in litigation unless there's corruption or a real good explanation for the delay. In this case, it became very clear by December that delay was the strategy at that time. So my attorney and the judge and Mr. Davis, of course my ex's attorney, were all shocked that I waived attorney-client privilege. But I knew that I hadn't asked for anything unreasonable. I hadn't been inappropriate or overly demanding or difficult with the attorneys or anyone else. I just, in good faith, needed some discovery to have some peace of mind. And once I waived any attorney-client privilege, it became very difficult for Ms. Hodge to explain why she was withdrawing. She couldn't hide behind attorney-client privilege for her rationale for withdrawing, but Judge Ayers didn't ask any questions. In fact, Judge Ayers initially scheduled the hearing on the motion to withdraw for out in January of 2025, but at Ms. Hodge's request, she moved it up so that the hearing occurred on December 13th of 2024, and that becomes an important date, scheduled on December 12th of 2024, giving me 1 day notice and ignoring my objections to moving it up and ignoring my unavailability for the hearing. I'll post some of the documents on that in the next one.